And when the jurors then came out, Lori rested. I looked over at their faces when she said, I rest. And none of them really, I didn't see much like, what? I didn't see much of a reaction. I'm sure in their heads they were thinking, what? Where's her defense? And they didn't get one. I've talked to jurors in the other cases with Lori, and they've all said, we wanted a defense. We wanted something. You want to make sense of it, or at least try to. And when there's nothing, what do you go with? Opening and closing statements, arguments are not evidence. It's just what's presented by the witnesses and the evidence. And the judge then read through their jury instructions very promptly. It's multiple pages. It's a packet. You can go watch the whole thing. I won't play it for you, but basically tells them what they need to decide when they go into the jury room. And then the final thing is closing arguments. Treena K's closing argument was around 45 minutes. She really laid it out. She put a timeline up on the screen and walked through everything and connected the dots. From the cell phone activity to the no tire on the Jeep to the license plate reader to the gunshot residue, all of it came together in this 45-minute summation of what we've listened to the past only 5 days. It feels like 5 weeks, but it's only 5 days. We're on day 5, really day 4. We've really in there 4 days. There was so much packed in there, 18 different witnesses. Quite a trial. I'm not going to play you all of Treena K's closing. We put it on our YouTube. You can go watch the whole thing. But I kind of butted together some of the highlights, how she started and then how she ended.
Who would want to kill you? That is a question that Officer Mary Ann Robb asked Brandon when she first arrived. That's a question that Detective Pillar asked Brandon when he spoke with him. Brandon Boudreau gave the exact same answer to both of these officers. He gave them 2 names. Lori Vallow, the woman seated over here, and Alexander Cox. He told them that he believed his shooting had something to do with an incident that occurred in Chandler in July of 2019, a couple months before this. He pointed them to that. He told them that Lori Vallow had lived in Texas and that the Jeep used in this shooting was from Texas. And then he told them what happened, how he had come home that morning. This Jeep was parked unusually close to his driveway, waiting. That he noticed there was no tire on the back, that he noticed that Texas license plate, that it was a 2-door Wrangler, and then he noticed that window go up. He saw the rifle come out. He saw what he believed was a silencer at the end, and then he heard and saw that bullet that hit the frame of his car, shattering the window right near his ear, causing that loud bang that he heard when that struck right near his head, mere inches away from him. The defendant has tried to explain away the evidence and questioning witnesses, asking if it's possible for a single piece of evidence to mean something other than what everyone knows it means. Is it possible that a Coke bottle broke in the street and one little shard stayed there right where Brandon Boudreau's Tesla was located when it was shot? A shard that looks just like the glass from his car in the driveway, inside the seats. Is it possible that a tire iron made that bullet hole in the Tesla? Is it possible that the GSR in the Jeep is hairspray and fireworks? Is it possible that a Jeep with Texas plates belonged to someone else who wanted to kill Brandon? Is it possible that Alex was in Idaho and called her on October 2nd at 8:02 for those 24 minutes? Don't fall for the defendant's questions about what is possible when the evidence shows exactly what occurred. The only explanation when we look at all of the evidence together is that this defendant conspired with her brother and others to try to kill Brandon Boudreau. The state asks you to look at all of the evidence, not just the is it possibles, and find the defendant guilty of conspiracy to commit first-degree murder. Thank you.
I would encourage you to go watch the whole argument. And Treena brought up the defenses that Lori raised of, was it a gray Jeep? Was it a green Jeep, camo Jeep? And she showed the Jeep in different locations, and it looked like it could be a different color, and based on the lighting and based on how it's viewed. She talked about some of the other things that Lori said, and yeah, go listen to it if you didn't get a chance to listen to it as it was happening. Then it was Lori's turn. And this was an interesting closing, and I'm going to play it for you. And I'd love to hear your thoughts in the comments.
When a family breaks apart, it is a tragedy, with the devastation far-reaching, affecting many people. I am not exempt from tragedy, none of us are. But what we learn from it is most important. Because of this experience, I've studied the law and the judicial system, and that knowledge will stay with me forever. When we experience tragedy, we can grow stronger from the experiences, and then those experiences are not all negative. You would think that often people in my position would feel defensive or angry, and from where I'm standing, I understand that very well. But I don't feel any of those things. You have watched me under pressure, under scrutiny, and even under attack. And I have shown you that I'm not on any of those things.
I'm going to object to character evidence and testimony that's not in evidence.
Ms. Daybell, could I have you pull that microphone a little closer, please?
You can't be upset with people who are forced to look at your life from a distance or judge it through a lens that's being intentionally distorted or being at least very limited. Like the lens the state has shown you on this event. There's so much more going on that is not included to your view. The law prevents some of these things from being shared in trial.
I object, Your Honor, to improper.
Sustained.
You have seen opinions formed by strangers trying to put together a narrative. I have shown you that basically there is no defense to what a person did not do or did not participate in. Other than what you've seen, which is no evidence that I made an agreement to commit a crime, because no such evidence exists. So I'm not defensive. I'm not angry. Nobody has all the pieces to this puzzle. It is complex. Like most families, this is a complex issue. And like the state, I was not there. But there is no agreement, no plan, no game. I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreau decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right. The jury is reminded that what is said in closing statements or closing arguments is not evidence, it is not testimony. The intent of the closing argument is for each side to argue what the evidence shows. Go ahead.
I did and have supported my niece Melanie when she suffered tragedy as a young child and during this terribly difficult time in 2019. We read the text from Brandon to me on June 25th, 2019, where he claims that he will never stop until he proves that I am responsible. Well, here we are, almost 6 years later, and I'm charged with conspiracy to commit first-degree murder. In order to have a conspiracy, 2 or more people have to make an agreement to commit a crime. There is no such agreement between me and my brother Alex, although I did love my brother Alex.
And I'm going to object again, Your Honor, to testifying.
Sustained.
There is no agreement that was shown to you between myself and Melanie Boudreau, although I love Melanie.
And I'm going to object again to testifying.
Sustained.
I cannot tell you what happened that day on October 2nd, 2019, because I was not there.
And I'm going to again object to testifying, and please strike everything the defendant has said.
All right. The defendant is admonished you cannot argue things that were not admitted into evidence.
The prosecutor wasn't there. Law enforcement wasn't there. only Brandon knows what happened before he called 911. Only Brandon said he will not stop. The fact that I supported Melanie in her time of need does not make me against Brandon. I had nothing to gain by Brandon being hurt. Brandon has worked with law enforcement for almost 6 years to make sure that I pay a consequence.
I'm going to object to misstating the evidence.
Sustained. The jury will determine what the evidence did and did not show.
Your job is to determine if I committed a crime. This crime. A conspiracy, an agreement, not cleaning out a garage, but an agreement to commit murder. You did not see an agreement. You did not hear an agreement. You heard Detective Duncan say that he had spent hundreds of hours going over my iCloud accounts. They have 19 years of my accounts. Text messages,
And I'm going to object to
calls.
misstates the evidence and no.
If there was an agreement.
Hold on. The objection sustained. The jury is reminded that they will determine what the evidence did and did not show. Go ahead.
If there was an agreement, they would have showed it to you. There is no agreement. We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought,
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing. Thank you.
That's the closing argument. Very reminiscent of her statement in Idaho when she was sentenced. That she could have said at her sentencing, asking the judge to if she's found guilty. But that is very different than a closing argument. And you can see the judge was saying, you can tell him that the judge is over this. He's over it. And I don't think she was listening to a word he said. When he said sustained, I think she just kept reading. She was going to say what she was going to say. I was just thinking it would have been fascinating if on day one, I could have brought somebody with me that knew nothing about this case to sit in the courtroom with me every single day. And at the end of every day, be like, what are you thinking and what questions do you have? And not tell them anything. Like have them be the fake juror. And every day, just talk with them and bring them on Courtroom Insider. Maybe we'll do that with Koberger, the next trial or something, or Corey Richens, an upcoming trial. Have some, you all probably wouldn't qualify because you're watching this, but really find someone that can give up the time to come in and sit, because I'm sure they have I would have a million questions like, why didn't this woman put on a defense? Family tragedy. Where's Melanie? Where's Chad? Are they been charged? She mentioned their fourth husband, Charles. Yesterday, we saw briefly on the rental form in Idaho, JJ and Tylee's name. Does she have kids? I mean, there's got to be a million questions going through their head. Well, Treena had an opportunity to rebuttal what Lori said, and she was fired up. Here's how she rebutted what Lori said.
The defendant wants you to think that Brandon has it out for her. She has tried to insinuate that Brandon was involved with working with Detective Pillar for years just to get her. But what you heard was that Brandon has actually been working with law enforcement on multiple investigations, and that in fact Melanie Boudreau is a subject of multiple investigations. So again, as the defendant sits up here and tries to portray and paint a picture for you of her innocence and sadness and family tragedy, she again misrepresents what was told to you at trial. She tells you there was no plan, but she ignores the facts and the evidence of a very obvious long plan. A plan that started when she began, this defendant, Lori Vallow, meddling in Melanie and Brandon's marriage. And when that marriage was finally ending, this defendant continued to help her cousin, or her niece, Melanie. She continued to aid her. And what we see in every one of these bits of evidence is a core group of people. This defendant, her brother Alex, Melanie Boudreau, and Chad Daybell. The four of them working together. Do we need to have words, a video? No, we do not. That is why there is that jury instruction on direct and circumstantial evidence, because you look at what is going on here, and it screams to you a conspiracy by this defendant, by Melanie Boudreau, by Alex Cox, and by Chad Daybell to kill Brandon Boudreau. Every action you see there, the defendant would like you to look at them individually and pretend that they don't all point to what happened on October 2nd. But everything they did leading up to then shows you a way to cover up and prepare for the murder of Brandon Boudreau. When we talk about a plan and this defendant's actions, the most obvious and screaming piece of information is this defendant holding on to her brother's phone for days, holding on to the 480-351-9120 number for days while her brother is gone, with her Jeep, without the rear tire, without the back seat, with a gun with him. That is part of the plan. That is the assisting, that is the promoting, that is the conspiracy that this defendant wants you to pretend doesn't exist. We don't need words. We have actions that are obvious, and they're done by this defendant and her co-conspirators. The state asks you to look at everything together, regardless of how many people want to cry up here, regardless of how many people want to try to testify. This is not evidence. What is evidence is what was presented to you in trial, and each piece of that tells you this defendant is guilty. And so I ask you to find her guilty of the conspiracy to commit murder against Brandon Boudreau. Thank you.
Well, regardless of how many people want to cry up here or testify. Impactful, memorable. And with that, the jury walked out into their room. They stayed about 15 minutes. Maybe they appointed a four-person, we don't know. And then they left, and they told everybody, not them, but the court staff said that we'll be back tomorrow at 10 a.m. So we are on verdict watch. 10 a.m. Phoenix time tomorrow. The jury reports back to the courthouse. We will see if we have a verdict by lunch or if it will continue into the afternoon. If the verdict comes back guilty, there will be an aggravating phase, however, where they can say guilty and then Treena K can try to prove that there were dangerous elements of this crime, which could increase Lori's sentence. The jury would say, yes, there are. However, just like in Charles' case, Lori submitted to it. She waived that part. So we won't hear that part, most likely. And then the judge will set a sentencing date, probably within the next 30 to 60 days. And then we're done. If she's found not guilty, she will also be set a sentencing date because she was never sentenced for Charles's crime, that crime, and that will also be 30 to 60 days. So he's going to sentence them both around the same time or at the same time. That's where Brandon will get to speak. Kay Woodcock will get to speak on behalf of Charles. Other victims will get to speak. Lori will get to speak. And then we're done. Maybe. Because it sounds like, based on Treena K, There's this investigation with Melanie. She was not shy about naming her as a co-conspirator regularly today and throughout this trial. So we'll see if they decide to charge her and bring charges, or if she just remains under investigation. Uh, and I do want to say too, she said repeatedly that Chad is a co-conspirator, but they told us, the Maricopa County Prosecutor's Office, in fact, let me find it. They told us that there was not, years ago, Maricopa County Prosecutor Chad Daybell, I'm just doing a quick Google. They told us that they did not think there would be enough evidence to indict him. So it was in July 8th of 2021. Prosecutors, it was a letter. Okay, here's the letter. Here we go. Let me make this big so you can read it. Maricopa County Attorney Nathan Duncan, defendant Chad Daybell, an attorney, has reviewed the report and made the decision to decline prosecution on the following charges: conspiracy to commit murder first degree. This was in relation to Charles, 7/11/2019. Property release, no. Release for prosecution over. Do not release property. Co-defendant Lori Vallow. So they declined it, and it was Treena K, who was the prosecutor, and Court TV. Oh, maybe they're sourcing us. There we go. Prosecutors in Arizona have declined to charge Chad Daybell in connection to the death of Lori Vallow Daybell's fourth husband, Charles Vallow. In a letter from the Maricopa County Alistair Adele to Chandler Police, the reason for not charging is no reasonable likelihood of conviction. The decision isn't unexpected, since an affidavit of probable cause in Lori's case says there is no obvious communication between Chad and Lori to indicate he was directly involved in the planning of Charles' shooting. So, interesting. Chad called Alex on the track phone. Well, he did call Lori, but this is a different case. This was in regard to Charles. So there was no obvious communication between Chad and Lori about Charles's shooting till after the fact. So he's not going to be charged. Chad isn't, but do they charge Melanie? We'll see. That is the question.